Hello, everyone. Welcome to my channel, and thank you so much for joining today's discussion. Whether you are watching me on YouTube, TikTok, Instagram, Facebook, or whether you're catching this at a later time, I'm so glad that you're here with me today. I'm immigration attorney Ebony Anuforo, and today we're going to be talking about a bunch of different topics, and I'm going to be answering some of the most frequently asked questions that I get from couples, from families, and from individuals just like you regarding U.S. immigration. In today's discussion, I'm going to cover everything from green cards through marriage, fiance visa, VAWA, citizenship waivers, and much more. I'm going to try to get through everything. All right. So if you want to grab a coffee or a notebook to take notes, let's do that. I have my water with me, my nice, gotta stay hydrated, my Pellegrino. I love sparkling water. Okay, so I'm going to just dive right in with some of the questions that I have. And if you have questions that you want to send me so that I can answer them during an attorney chat here on my different platforms, please send me your messages. Send me a comment, send me a DM, send me an email, or you can WhatsApp me, right? And I'll try to answer them here for you. So the first question I'm going to ask is, why did I only get 2 years, a 2-year green card? So this is a great question. If you're married for less than 2 years, at the time your green card was approved, then you will receive a conditional green card for 2 years. So what happens is you'll have to file the form I-751 to remove the conditions in order for you to get a 10-year green card. And that also comes with its own deadlines and its own requirements, right? You have to do it, 90 days before your conditional green card expires. And the reason why the government gives you a 2-year green card is because your marriage is new in their eyes. So they want to make sure that they check in with you to make sure that you are continuing to build a life together and you're continuing to be married. But, there are some situations where people do get divorced and they separate before you get to that 2-year mark, and it's okay if you happen to be divorced by then. You would just have to ask for a waiver of the joint filing and bring evidence of your divorce. Some people, their relationship ends because of abuse in the relationship, and if that is the case, you also have the option to submit a waiver based on being abused by your spouse. Next question, what happens if my spouse and I separate before filing the I-751? Well, I think I just answered that question. You can still file, but you'll need to request a waiver of the joint filing. Again, this does happen. It's a lot more common than you think. So if you're divorced, you just let them know that you're divorced, provide evidence of that divorce. If you are still married, but you're being abused and you're separated, right? You provide evidence of that abuse and request a waiver. All right, next question. Can I apply for a green card if I came to the US on a tourist visa and marry a US citizen? So yes, many people adjust their status after entering on a visitor's visa, a B2 visa. The key is proving that the marriage is real and not fraudulent. That's what is the most important when it comes to applying for a marriage-based green card. You need to show also that you didn't enter the US intending to stay here permanently, right? So I typically will say when you come in on a B2 visa, which is a visa that has non-immigrant intent, meaning the purpose of your coming was to visit. You don't want to do anything that shows immigrant intent within the first 90 days of you being here. So if you got married within the first 90 days, that might be a little bit of a red flag because it looks like you had intent to stay here. However, if it's been more than 90 days and you got married and you came here legally with the visa, then you will be able to apply for a green card. So what is the difference between a fiance visa and getting married first, then applying for a spousal visa? Okay, so the fiance visa lets you enter the US to marry within 90 days. That's what we call the K-1 visa. Everyone is familiar with the 90-day fiance. So it allows you to, the foreign spouse, to enter into the US, and you have 90 days to marry your US citizen spouse. If you marry abroad, the US citizen would instead file a spousal petition for you, the Form I-130 petition, and then you would go through consular processing. So each route has its own pros and cons, depending on your situation. But the difference is, if you get married first, if you get married back home abroad, then you would have to go through consular processing before you get into, you're allowed to enter. You'll interview in the consulate or the embassy back in your home country. Can I still apply for a green card if I overstayed my visa? So yes, if you married a US citizen and you entered legally, the government will typically forgive you and forgive your overstay and allow you to adjust your status. But if you didn't enter legally, you might need a waiver for your illegal entry and your unlawful presence. And if it's approved, you'd have to go through the process back home and go through consular processing. So what if I am in removal proceedings, but I'm married to a US citizen? Okay, so if you're in removal proceedings, you can ask the court to possibly terminate the proceedings and pursue your green card application with USCIS. You can ask them to do that. Your attorney will write a motion, or you would seek the adjustment of status within the court. So every case is different. There might be some benefits for having it terminated and going through the adjudication process with USCIS, and there may or may not be benefits for keeping it in immigration court. But yes, you can get married if you're in removal. What is VAWA and who qualifies? Okay, so VAWA allows certain abused spouses of US citizens or green card holders to apply for a green card without their spouse's help. So I always like to say that abuse doesn't have to be physical. People just assume it means you were physically abused, but no, you can also qualify for this benefit if you were emotionally or verbally or financially abused, if you suffered extreme cruelty in the marriage, if you are the parent to a US citizen child who is 21 years or older, or even the child, right, to a US citizen or green card holder, you qualify to apply for VAWA if you were abused in the relationship. What if I already filed a joint I-751, but now I'm experiencing abuse? Okay, so this does happen. So you can notify USCIS and ask them to convert your case to a waiver based on abuse. And once that's done, you don't need your spouse's help to continue the process. It now becomes a self-petition, similar to filing a VAWA petition. So how do I know if I need a waiver? That's a good question. So you may need a waiver if you, again, like I said earlier, if you entered without inspection, you're definitely going to need a waiver. If you overstayed, right, your visa, I did say that there is an exception when you're applying for adjustment and married to a US citizen, but if you're not, you would need a waiver for your unlawful present. If you've ever misrepresented something, so if you lied about something, if you committed any immigration fraud in the past, if you have any criminal history that the government considers you to have a lack of good moral character, or they consider it to be a crime involving moral turpitude, you'll need a waiver. If you're inadmissible for any reason, you might want to talk to, not you might, you should speak with an attorney to evaluate your case, because you're going to need a waiver if you're going to apply for any types of immigration benefits. So what is extreme hardship and how do I prove it for a waiver? So the thing about with waivers, right, and proving extreme hardship is that you have to remember that the extreme hardship isn't about you. Okay, it's about how your US citizen or green card holder relative will suffer if you're not allowed to stay. A lot of people get confused and they think it's, oh, I'm going to suffer if I get deported back to my home country, and that's not the case. They care about the qualifying relative and how they would suffer if they were separated from you, if you were deported back to your country and they weren't allowed to be with you. And you can talk about, how they would suffer, hardship to their health, sometimes finances, emotional well-being, talk about other types of issues that come along with family separation or more, how they would be affected if they were forced to go back to your home country. You can talk about the country conditions. There's a lot of ways that you can show hardship to your qualifying relative. Okay, so this actually came up before. What if my K-1 visa was approved, but the embassy denied me because of a past conviction? This actually came up. I actually am working on a case. It's pending right now, a case similar to this. And what I'll say is that you may still be eligible to apply for a waiver, right? It depends on the crime that you committed, right? If it's a crime involving moral turpitude, I recommend talking to an attorney so we can analyze your record and explain why you deserve a second chance. And maybe you have rehabilitated since then. Maybe you have a good moral character since then. Maybe there are some, different circumstances that led to the particular crime. Ultimately, you want to talk to an attorney and see if a waiver is an option for you if you were denied at the embassy for a past conviction. So how long does a VAWA case take to get approved? Okay, so the VAWA timeline is going to vary. Right now, as we're speaking, VAWA is taking about 42 months on average for approval, right? I remember when it was a lot shorter than that. We have a lot more people applying for VAWA. There have been delays since the pandemic that USCIS is still, kind of working through. There's just so many factors that contribute to delays and long wait times. So it really is going to depend, but I'm going to say it's definitely taking more than 2.5, 3 years at this time. Things can change. Um, However, the good thing is if you're applying for adjustment of status as well, then you qualify for a work authorization for a work permit, and you'll be able to work while it's pending. And then once it's approved, you'll move forward with the I-45 and hopefully get a green card. Can I apply for a VAWA if I'm divorced? Yes. As long as your divorce occurred within 2 years of the filing, as long as it's not more than 2 years old, then you are still eligible to apply for VAWA. Okay, I've had my case pending for over a year. What can I do? Okay, so if your case is outside of the normal processing times, you can submit a service request. You can contact your Congress member, you can call USCIS and let them know, hey, my case is outside of the normal processing times. Or you can consider filing a mandamus lawsuit to get USCIS to take action. I would say if this is the case for you, talk to an attorney. There's some different strategies that attorneys use. Some attorneys are very aggressive and they file mandamuses, because they feel like that's going to kind of nudge USCIS to take action. Some attorneys might say, depending on the facts, you might not want to file a federal mandamus lawsuit. It really is going to depend on the case by case basis, but those are your options. Okay, how do I qualify for US citizenship? Okay, so most green card holders qualify after 5 years for naturalization, or 3 years if you're married to a US citizen. You'll need to show that you have physical presence in the U.S., good moral character, continuous presence in the U.S., and that you have maintained the jurisdiction at your current address for at least 3 months. There's also a civics and English test that you have to pass before you are approved for naturalization and giving the oath ceremony. Okay, so it depends on your case. For some people, it'll be after 5 years. For some others, it'll be 3 years. Okay, so what is TPS and who qualifies for it? So TPS stands for Temporary Protected Status. It's for people that are from certain countries where it's unsafe for them to return home. And that could be for many different reasons. It could be for maybe there's been some natural disasters, that happened in the country. Maybe there's some serious civil unrest that's going on in the country. But you must meet you have to meet certain requirements in order to qualify for TPS. And the government is the one that decides which countries are designated for TPS. And that changes because TPS is not forever, right? So certain countries will be designated for temporary protected status for a time period and will eventually be taken off and removed from that status. So you want to make sure that your country is actually designated for temporary protected status, because if it's not, then that wouldn't be an option for you, even if there is any of the things that I mentioned happening in your country. Okay. All right, so that's all the questions I want to answer, but I have a question that I asked, and my question is, what is the biggest mistake that people make with immigration cases? That's my question. That's my frequently asked question for today. And my answer to that question is trying to handle complex cases on their own without fully understanding the risk or waiting too long to get the help that they need. Okay, so immigration law can be very unforgiving. You know, it's always better to ask questions before you file, talk to an attorney, especially if you have very complicated facts in your case. I know there are people who are able to file a petition on their own. I know a lot of people look at immigration like, oh, it's just form filling. But immigration is more than just form filling. Attorneys, we're not just here to fill out the forms for you. We understand the process, we understand the law, we're able to analyze each case on a case-by-case basis, and we're able to make legal arguments for your particular circumstances, for the facts in your case. And we're even able to analyze and determine whether or not it's even a good idea for you to apply for a certain benefit. Sometimes people assume that, they should apply for a benefit because they heard a family friend did it and it worked out. And then they end up getting themselves in bigger trouble and putting themselves out there and ending up in removal proceedings. Sometimes people apply for benefits and they're inadmissible or they have a prior crime or an admissibility issue in their case, and now they've availed themselves to the US government. A common example is applying for naturalization, and you have a really, sketchy immigration green card passed, so you don't want to put yourself in a situation where you can make your immigration status worse. You want to work with an attorney who's experienced with dealing with complex cases. You want to at least schedule a consultation, talk to a lawyer and see, ask questions. There's nothing wrong with asking questions. You watching this video now is a step in the right direction because you're seeking information, you're seeking knowledge about the law and about immigration. So that's great. I would say the next step is to talk to a lawyer if you have a complicated case and you don't know whether or not you should apply for a benefit, whether you qualify for a benefit. Speak to an attorney to at least get an evaluation in your case. We do offer consultations. You can visit my website to book a call with me. And I represent clients in all 50 states. U.S. immigration law is federal, so we can represent clients anywhere in the world regarding U.S. immigration. So if you would like to speak with me, again, the link is in the description. You can contact my office. I would love to speak with you. And if you have any questions that you'd like me to answer during another one of my immigration chats, please send me a message, send me a DM, leave a comment, and I will talk to you in the next one. Take care. Bye.